Breaking news tonight in the case of Bryan Kohberger, the man accused of killing 4 Idaho college students. His lawyers now calling for the grand jury indictment to be thrown out altogether. In a just released motion, Kohberger's attorneys say the grand jury was, quote, misled as to the standard of proof required for an indictment. Prosecutors used a grand jury earlier this year to indict Kohberger instead of what's called a preliminary hearing, where a judge would hear evidence and determine if there's enough case to go to trial. Either one is acceptable under Idaho law. But Kohberger's lawyers argue the grand jury should have been instructed that the standard of proof based on what was presented to them is, quote, beyond a reasonable doubt, meaning a very high standard. But they weren't. They say instead they were given a much lower standard. Just, quote, a reasonable ground for believing that a particular individual has committed a certain offense. It makes a huge difference. Now, if true, that would mean the grand jury was told they could indict on a lower standard of proof. Now the defense wants the indictment thrown out or for the judge to order a preliminary hearing. Now, this motion comes just days after Kohberger's defense team filed paperwork saying that if the case does go to trial, they intend to present an alibi. It's a requirement in Idaho to inform the court of that. His attorney writing evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules, as well as statutory requirements. The document stops short of saying where Kohberger was at the time of the killings, because, of course, that's the question we'd all like to know the answer to. Instead, saying that evidence of an alibi, quote, may be offered through cross-examination of state's witnesses and defense experts. He's facing 4 counts of first-degree murder, the stabbing deaths of Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. If convicted, he could face death by firing squad because of a recent change in Idaho state law. Joining us now, Jesse Weber, attorney and host on the Law and Crime Network and a NewsNation legal contributor, and Anjanette Levy, a correspondent and host for the Law and Crime Network. Both have been following this case closely. All right, Jesse, let's start with this motion to throw out the case. Yep. Lay out what is the defense's argument.
Okay, so it's a really interesting argument. They are looking at a statute that's been on the books in Idaho since the beginning. And what this statute basically says is a grand jury can only come back with an indictment if they look at all of the evidence and, quote, if it would warrant a conviction by a trial jury. And then they go through a long history lesson about what case law says and what statute says. And they say that language means beyond a reasonable doubt.
Much higher standard.
A much higher standard. And they say, listen, if that's the case, and this jury wasn't read the proper standard, it has to be thrown out.
And what do you make of the argument?
It's interesting because, what are we, in 2023? Why has this not been resolved beforehand? Now, I did a little research. There were courts that asked this question before, but it never came to a consensus. They cited some of those cases before. The most interesting argument that they put forward is they cited a statute that was put on the books by the Supreme Court, or was interpreted by the Supreme Court. And that statute basically says what you just said before. A grand jury can come back when you find probable cause. Their argument is that's not valid. You go with the old statute, and they think that trumps it.
And Jeanette, I'm going to be asking you about the alibi primarily, but anything you want to add on this breaking news of this motion that was just released?
You know, I reviewed it and found many things that Jesse already covered, and the fact that they do cite the Supreme Court saying that all they have to do is find probable cause to indict. But it is an interesting argument. I don't think it's going to fly, though. I just don't think this is going to happen. I think it's clear the defense wanted a preliminary hearing in this case. They wanted to be able to question and cross-examine some of these witnesses before trial.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.